bestseller on Amazon. He has written more than 5 dozen law review articles that have been cited nearly 1,000 times. He was selected by Forbes magazine for the 30 Under 30 in Law Policy and is the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. He also blogs at the Volokh Conspiracy and tweets at Josh M. Blackman. Please welcome me in, please join me in welcoming Professor Josh Blackman. Thank you.
Thank you so much. It's good to be back here in Toledo, see all of my old friends. The Second Amendment for many years was more or less a dead letter in the Constitution. There were simply no cases the Supreme Court took deciding that. But in the span of only 2 years, the Supreme Court decided two landmark Second Amendment cases. District of Columbia versus Heller, 2008, held that the Second Amendment guarantees an individual right to keep and bear arms that is not connected to malicious service. And McDonald v. Chicago, 2010, applied this right to the states via the 14th Amendment. The precise holding of both cases, however, was limited to the issue of whether the federal and state governments could prohibit the private ownership of handguns inside the home. Heller and McDonald did not address a broader question. Does the Second Amendment guarantee a right to carry a firearm outside the home? Over the ensuing 12 years, the lower courts would divide on this question. In New York State Rifle and Pistol Association versus Bruin, the Supreme Court held that the Second Amendment does protect an individual right to carry a firearm outside the home. Brandon Koch and Robert Nash were law-abiding citizens of Rensselaer County in upstate New York. They were members of the New York State Rifle and Pistol Association. Koch and Nash both wanted to carry a handgun outside their homes so they could defend themselves. But New York required more. Specifically, applicants needed to demonstrate that they had what's called proper cause to carry a firearm. Koch and Nash had to show a special need for self-protection distinguishable from that of the general community. It was not enough to show that they lived or worked in a high crime area. Rather, they had to provide evidence of, quote, particular threats, attacks, or other extraordinary danger to personal safety. New York had a law known as a may issue regime. That is, the state may issue a carry license at its discretion. By contrast, more than 40 states employed a shall issue regime. The regulations provided that the government shall issue a carry license if a person meets certain general objective criteria, such as passing a criminal background check or taking a special course. Now, this was an objective standard, not subjective. Koch and Nash did not have a special need, distinguishable from that of the general community. They simply wanted to carry a firearm for self-defense. Therefore, a judge in New York determined that Koch and Nash did not demonstrate, quote, proper cause and denied their licenses. This denial was upheld by the federal courts. On appeal, the Supreme Court reversed the denial by a 6-3 vote. Justice Thomas wrote the majority opinion, which was joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Barrett. Justice Breyer wrote a dissent, which was joined by Justices Sotomayor and Kagan. The case involved 5 primary issues. The court began with methodology. In the decade following Heller and McDonald, the lower courts often reviewed gun control laws with strict or intermediate scrutiny. Justice Thomas's majority opinion rejected any means-ends balancing test. No scrutiny at all. Instead, the court favored a test rooted in the Second Amendment's text as informed by history. Specifically, the government has the burden to affirmatively prove that its firearms regulations is part of the historical tradition that delimited the outer bounds of the right to keep and bear arms. Then the court will assess whether modern firearm regulations are consistent with the Second Amendment's text and historical understanding. In dissent, Justice Breyer wrote that judges are not equipped to resolve difficult historical questions or to perform searching historical surveys. Indeed, during oral argument, Justice Breyer said the historical evidence conflicted with Heller. He recalled that in McDonald, we had professors of history who ran departments in the English Civil War, and they all said the history in Heller was wrong. Breyer continued, "This is a wonderful case for showing both sides, so I'm not sure how to deal with the history." Likewise, Justice Sotomayor added that the history and tradition of carrying weapons in the states gets a lot of deference. Justice Thomas disagreed. In his view, courts resolve legal questions rather than resolve historical questions in the abstract. And when the parties present courts with a historical record, courts can decide based on which party made the stronger case. The second part of the opinion. The court held that the Second Amendment protects a right to carry a handgun outside the home. Indeed, New York did not dispute this point. The word bear has some meaning. Justice Thomas explained that the Second Amendment does not draw a line between the home and the public. The text refers to a right to keep and bear arms. And the word bear in the Second Amendment naturally encompasses public carry. But confining the right to bear arms to the home would nullify half of the Second Amendment's operative protections. Moreover, the need for self-defense and confrontation can surely take place outside the home. The court held that Koch and Nash have a right to bear arms in public for self-defense. Next, the court used analogical reasoning. Remember analogical reasoning? Remember the LSAT? If this is to this, then this is, remember this? Okay? The court used analogical reasoning to determine if New York's proper cause standard was, quote, relevantly similar to historical regulations on carrying arms. During oral argument, Justice Thomas asked Paul Clement, the lawyer for the plaintiffs, about analogical reasoning. He asked, if we analyze this with history, tradition, and the text of the Second Amendment, we're going to have to do it by analogy. Thomas asked Clement if he could give me a regulation in history that would form a basis for legitimate regulation today. Thomas inquired, if we're going to do it by analogy, what would we analogize New York's law to? what are the historical analogs? In the majority opinion, Justice Thomas looked to potential analogies from 4 periods of time. First, the court looked to laws from medieval to early modern England. For example, the 1328 Statute of Northampton prohibited people from going armed. During oral argument, Paul Clement stated that the statute was a prohibition on either carrying unusual and dangerous weapons or using common weapons in a way that terrorized the people. However, there was another way to read the statute. Barbara Underwood, the New York Solicitor General, countered that carrying a gun would, by definition, terrorize the public. She said guns were deemed to be offensive weapons per se, and thus carrying arms was always prohibited. But the court agreed with Clement and determined that the Statute of Northampton only prohibited bearing arms in such a manner as to spread terror among the people. Justice Thomas jumped ahead to the laws in the American colonies and the early republic. During that period, there was little evidence of regulating public carry by the general public. Prior to the Civil War in antebellum America, state governments did enact restrictions on public carry. However, Justice Thomas observed, none of these restrictions impose a substantial burden on public carry that were analogous to New York's May issue regime. At most, the manner of public carry was subject to reasonable regulation. But the states did not prevent law-abiding citizens with ordinary self-defense needs from carrying arms in public. After the Civil War, Southern states violated blacks' rights to keep and bear arms, but these racist Jim Crow laws were not reliable evidence of how the right to bear arms was understood. And in 1866, Congress reenacted the Freedmen's Bureau Act. This statute expressly authorized the Bureau to protect the constitutional right to bear arms. According to Justice Thomas, limits on carry in other states were still consistent with the right of the public to peaceably carry handguns for self-defense. Finally, some Western territories prohibited people from carrying pistols. But the court dismissed the relevance of these laws, West, which appeared to be passing regulatory efforts by not yet mature jurisdictions on the way to statehood. These laws, Thomas wrote, were not part of an enduring American tradition of state regulation. Justice Thomas concluded that American governments simply have not broadly prohibited the public carry of commonly used firearms for self-defense. We'll just do the food in a few minutes, guys. Just hang tight. We'll just do it between we break. So just hang tight. Okay. Justice Thomas concluded that American governments simply have not broadly prohibited the public carry of commonly used firearms for personal defense. Based on this history, New York's May issue regime did not have an adequate historical analog. In light of this history, the court held that New York's proper cause requirement was therefore unconstitutional. In the fourth part of the majority opinion, Justice Thomas identified certain limits on its holding. The court did not cast doubt on the shall issue laws in 43 states. These laws, which often require applicants to undergo a background check or pass a firearm safety course, are narrow, objective, and definite standards. But the court counseled that these regimes may be unconstitutional if put toward abusive ends by means, for example, of lengthy wait times or exorbitant fees. Justice Kavanaugh wrote a concurring opinion that identified two other limits on the court's decision. First, Kavanaugh wrote that states can require applicants to satisfy a background check, firearm training, as well as a mental health records check. This was not something New York had. New York did not have a mental health record check. But I have to think history may have affected Kavanaugh's vote here. Shortly before Bruen was decided, there was an attempted assassination on the justice by a person who had mental health concerns. So I think, what do I know, that Justice Kavanaugh's experience may have led him to include mental health checks in the list of potential criteria to decide who can have a license to carry a firearm. Justice Kavanaugh also repeated the paragraphs from Heller that approved of long-standing prohibitions of firearms by felons and the mentally ill, as well as laws forbidding the carrying of firearms in so-called sensitive places. Sensitive places. The Bruen majority did not comprehensively define the term sensitive places. This will come up later. The fifth element of the case focused on guns and public policy. Justice Breyer's dissent highlighted how many Americans were killed with firearms and the number of mass shootings. Indeed, several months before Bruen, there was a mass shooting in the New York City subway. Justice Breyer criticized the court for, quote, severely burdening states' efforts to reduce gun violence. For Justice Breyer, judges should exhibit modesty and restraint when they interpret and apply the Second Amendment. The Supreme Court rejected this approach to judging. Justice Thomas quoted from McDonald v. City of Chicago. Quote, the right to keep and bear arms is not the only constitutional right that has controversial public safety implications. If you think of the Fourth, Fifth, and Sixth Amendments, these are all rules that make it harder to prosecute dangerous criminals. The First Amendment protects speech that can lead indirectly to violence. Lots of parts of the Constitution can lead to public safety concerns. In Bruen, the court rejected this approach to judging altogether. Thomas wrote, the court should exhibit unqualified deference, not to the state, not to legislative interest, but unqualified deference to the right of law-abiding, responsible citizens to use arms. Now, in the wake of Bruen, the lower courts will have to decide how to assess various types of gun control restrictions. And I'll give you just a few tips or previews of where we're headed. One of the most aggressive states in the wake of Bruen has been New York. Shortly after Bruen, New York enacted this very comprehensive law, which was no doubt drafted in advance. It was just sitting there on someone's desk waiting for the court decision to come out. And I'll just walk you through some of the provisions. In order to have a handgun license, you must pass a gun safety course, go through a criminal background check, and have good moral character. Good moral character. Now, a lot of you are perhaps 2Ls or 3Ls. You know the bar has a character and fitness exam. So there is some standard to have good moral character, but at least in the bar, it's based on things like honesty and integrity. But the New York law is a little bit different. New York requires that you submit personal references who have to provide statements of this person's moral character. And New York wants a copy of all of your social media handles so they can dig through your tweets and Facebook posts to see if you've had any sort of hateful or harmful speech. So here we're seeing the First Amendment and the Second Amendment collide head on. Then we get to this concept of sensitive places. Heller defined a few, such as government buildings, schools, and the like. New York defines sensitive places very, very broadly. All public transit, all schools, all houses of worship, even where the members of the house of worship want their parishioners to be armed. Indeed, a number of clergy have actually filed suits saying they've been carrying for years with licenses, but now they're not permitted to do so any longer. So now you have the Second Amendment and the Free Exercise Clause intersecting. My favorite sensitive place actually is Times Square. Now, I don't know how many of you have been to Times Square. Maybe some of you have. I've always understood Times Square to be 4 or 5 blocks where some big theaters are. New York defines it to be a 35 square block area. Basically, the entirety of the middle of Manhattan is now a sensitive place. I went there about a month ago just for curiosity, walking around. And what New York said is they'll put signs on every corner saying you are now entering a gun-free zone. I didn't see any of those signs. I saw one, and it was basically zip tied to a streetlight. So it's hard to even see. Now, if you live in that sensitive place, you can carry your gun, but don't you dare stop there. You have to keep going. New York also is considering an insurance requirement. That is, if you want to carry a handgun outside the home, you must pick up a policy from an insurance provider, such that if you were to use the gun to harm someone else, insurance will cover it. Now, these policies don't actually exist, right? So New Jersey and a few other states are requiring people to buy policies that cannot be sold. If you take insurance law, there's something called a moral hazard, right, Dean? Moral hazard, where usually an insurance company will not insure you against intentional torts or intentional acts. That is, can I get a murder policy that if I just murder someone, you'll cover my, no, that's not going to fly. So jurisdictions are requiring or considering requiring the purchase of a insurance policy that frankly doesn't exist, and I'm not sure any insurance company would ever actually sell. So what we're seeing in the wake of Bruin are jurisdictions who are just making it as hard as humanly possible to actually get one of these licenses. I think the requirement to show social media handles is not going to fly, especially they can sort of scrutinize it for harmful speech. That's not going to work. There's a doctrine in law called the Unconstitutional Conditions Doctrine. That is, the government cannot condition the exercise of one right based on giving up another right. So, for example, if you want to live in public housing, can you give up your Fourth Amendment right? That is, the government can search your house at any point. Or if you want to, there's always a lively issue, if you want to sign up for public health benefits, welfare, can you be subjected to random drug testing, which might otherwise violate your Fourth Amendment rights? So there's actually some body of case law governing how you can restrict one constitutional right by giving up another one. The sensitive places one, I think, is also very tricky because, look, New York is unique, and we have to concede this. There is no subway in Toledo, right? There's no subway here where people are sort of crammed together and, riding in a train car for hours on end. But also people who take the subway have to go through rough neighborhoods In many cases, the need for self-defense is most acute when you're taking public transit, right? Not everyone has a nice Ford F-150 to drive around in Manhattan, right, Sean? Right? People don't have these cars; they don't exist. You couldn't try park. He was complaining, oh, the spot is so small. Can you imagine parking your car in New York? Wouldn't work. Wouldn't work. Another area beyond the sensitive places that always comes up is the type of weapons that can be carried or even owned. Many states have bans on so-called assault weapons. This term is not really meaningful. The actual definition of assault weapon is largely cosmetic. It refers to how does a gun look? Does it look really scary? Does it have various pieces on it that make it look a little bit harder? They don't affect how powerful the gun is. Maybe at the margin there's a little handle you can hold on to, but the guns are just as lethal. Under the old rules in Heller McDonald, most of those bans were upheld. They might be vulnerable now. Another issue involves former felons. Now, not all felons are violent. We have non-violent felonies. Think of Martha Stewart in a white-collar offense, right? Why can't Martha have a gun, right? She just lied, insider trading, whatever, right? Obstruction. Why can't she own a gun? Before Justice Amy Coney Barrett went to the Supreme Court, she wrote a lengthy opinion discussing whether there's a history of non-violent felons being disarmed? And the answer is no. Usually only violent felons are disarmed. The reason why is because they were executed. There was only one punishment for being a violent felon. The gallows, you were hung, right? Or hanged. I always forget that one. Lee will correct me later, right? Can you now restore the rights of non-violent felons? Now, I know you guys want your food. I'll just wrap up in 1 minute. Justice Breyer's dissent in Bruin was really his last dissent, because a couple days later he announced his retirement from the court, and then he issued his oath, the oath of office to his former law clerk, Justice Ketanji Brown Jackson. So we have a new court. There are no gun cases on the docket this year. That might take another 2 or 3 years. But whatever this historical analogy is, this new thing the court made up, we're going to have to figure out where the court will sort of define and how to make it work. All right, that's all I have. Let's take a 5-minute break. Get your food. I know you guys are staring at it, and then Lee can come up and maybe we can chat a bit. Thank you so much. Okay, food. Yes, I didn't want all the crinkling in the papers while I was speaking. It's distracting. All right. Yeah, I'll go sit down over here. Thanks, Lee. I would never interrupt with Chick-fil-A. And I got my thing running, just so you know. All right, well, the rest of you are getting your food. Thank you, Professor Blackman, for making your way up north, even though it's fall and cool here. It's cold. I didn't bring a jacket. I don't like this. It's probably nice. It's 80 degrees. Becoming a favorite expertise, Blackman's an expert in a lot of areas. And my role today is to provide a couple of comments. If Mr. Blackman wishes to respond, that's up to him. To maybe tease out some of the implications of what he had said. So I thought one of the most interesting things about the Bruin case was that Mr. Blackman, I thought, did a really great job describing and the express use of analogical reasoning, which I don't know if there's a case that's been as express ever. So a couple of my questions deal with that. So one is Bruin the example of originalism or something else? So I think there are ways in which one can characterize it as an originalist opinion. So, for example, let's say that it's difficult because the historical record is unclear about what the original meaning of the Second Amendment is. Some things we know for sure. It protects an individual right to bear arms, but maybe other things are less clear. So one way to respond to that epistemic difficulty is to put the burden of proof on the government and to say, government, you look in the history and tradition and find examples of similar regulations. So it's a way to avoid having to fully articulate what the original meaning of the Second Amendment is, while still having another way to provide evidence for whether or not that meaning, indeterminate though it may be, may apply or not apply in a given circumstance. So is it originalism or is it something different? Second, even though the Bruin case, I think, most expressly uses analogical reasoning, it's come up more frequently recently in other areas. So the area that I think most of is the Establishment Clause context, where the Supreme Court this last term, we're not doing lemon anymore. And what we are doing is we're looking at history and traditions. So is there some reason why in the Second Amendment context, the Establishment Clause context, and maybe other contexts that you can point to, where the Supreme Court is looking to history and tradition in a way that it hadn't been doing, or at least as robustly, even 5 years ago? Is there some connection between the two? Is it, like I was suggesting earlier, that the original meaning of the Establishment Clause is widely disputed, the same way that the original meaning of the Second Amendment is widely disputed among scholars, and therefore this is a way to overcome that epistemic difficulty? Is your response to maybe the perceived intransigence of state officials? So you have schools. So think of the Kennedy case. You've got schools, and the schools just keep on excluding religion, despite the 11 test being on its last leg and now having no legs. And so, in response to that intransigence, what do? You have a clear statement that we do things within the history and tradition of American people. And maybe New York, and Mr. Blackman gave the example of New York's response to Bruin. Already the response might be perceived as a lack of good faith by the members of the court. Or, and this maybe is most radical, is Bruin an example, is the Establishment Clause doctrine an example of Justice Thomas and other justices, sometimes you get 6 justices, sometimes less, who are skeptical of balancing tests? And one way to get rid of balancing tests is you have a categorical statement about what the right is, the right to even bear arms, and then you use analogical reasoning with this burden of proof to answer concrete questions. So is this a challenge to balancing tests? And my last question, for what it's worth, would be McDonald, Heller, and the Bruin case all focus on the self-protection rationale of the Second Amendment. In the scholarly world, there's another rationale, what's called the anti-tyranny rationale of the Second Amendment. I don't think that made an appearance in Bruin. Do you think there's any implications for that alternative rationale in the Bruin analogy? So really great comments. I'm looking forward to your responses.
All right.
We don't talk about Bruin. No, I'm just you guys don't have kids, obviously. Bruno. No, we don't talk about Bruno. Get it. Thank you, Lee. Always. Encanto, no? It was a big movie. Thank you so much for that, Lee. I'll start with the last one. We often think of the Second Amendment. What's the purpose of the Second Amendment? Well, some people say hunting. It wasn't hunting. Some people might say defense in the home. Okay, that's a good start. But the concept of defense wasn't just against saucy intruders, as Pearson v. Post might call them. See, I got you a property reference. The broader purpose of the Second Amendment came after an American Revolution, where a bunch of armed, ragtag, untrained militiamen took on the greatest army in the world, the Redcoats, the British. And in many regards, the right to bear arms was understood as a right to fight against tyranny, fight against oppression, to use the phrase that Lee used. And if that's right, the sorts of weapons we need might be a little bit different. Indeed, I actually think the strongest case can be made for what kind of weapons we have under the Second Amendment. It's not a little handgun. It's an M4. It's whatever arms would be used by a militia member today to fight in a war. right? You might say, well, Josh, a militia can't fight against, a huge standing army. I don't know, Ukraine, Iraq, Afghanistan. Insurgencies are very effective all around the world. So if we start at a starting point that the Second Amendment is about protecting our right to fight government itself, it's a much more robust right, and a lot of these regulations would not even fly. To Lee's next point about analogy, a text, history, and tradition, right? The court really seems to be leading towards some sort of historical approach. Is it originalism? I'm with Lee. I don't know. Bruin didn't really talk much about original meaning. We've been, we scholars, professors, who are we? We've been writing about this stuff for 20 years. And we put all these amicus briefs in. And then Justice Thomas said, hold my beer. Let me make something new up. Right? So we have this entire new doctrine of text, history, and tradition. So just pause for a minute. What does tradition add that history doesn't? Right? Text and history, okay, I get that. Text, we look at meaning the words. History, what was on the founding. But tradition seems explicitly stuff that happened after the founding. And I think what the court's saying, I think Kavanaugh in particular is saying, is that if there's been something been done for a long time, we're not going to disturb it. Right? So even if something was unconstitutional in the in the abstract, we're not going to disturb it. New York's law, New York's gun law is 115 years old. That's pretty old. None of us are that old, but I guess that wasn't old enough. So you have to go back even further, I suppose. But there are other laws that have been around for a long time, maybe 150 years, that might survive muster. Now, in the Establishment Clause context that Lee mentioned, Justice Gorsuch has made the point differently. He says, if something's unconstitutional, I don't care how long you've been doing it for. There's no adverse possession in Constitution. I teach property also. There's no adverse possession for constitutional law that if you keep violating the Constitution, you get to do it indefinitely. I didn't make that up. Justice Scalia used an analogy in Noel Canning that if you keep making these unlawful recess appointments, it doesn't create a new power. I think Scalia got from Jonathan Turley, so we all steal from each other. But who cares about tradition? But the court does seem to go to Lee's first point to be getting rid of balancing tests. They don't want to ask, is this a narrowly tailored way to accomplish some compelling governmental interest? They don't want to give the courts that much discretion, right? They want to hamstring the lower courts and put the thumb on the scale on the side of individual rights. Because what happened in the wake of Heller and McDonald is the lower courts kind of ignored Heller. They just said, oh, we're going to apply intermediate scrutiny, which means the government wins. In every case, it was the same thing. I litigate these cases. I got exhausted. It's the same thing. Oh, well, is this in the core of the Second Amendment? No. Okay, it's reasonable. Okay, government wins. It was the same thing in every case. Same thing over and over again. So now we get to what the court actually adopted, which was analogies and analogical reasoning. Now, I don't know about you, but I didn't like the LSAT very much. Maybe you did. Maybe you're a sadist or masochist. I don't know. And I don't know how good judges are at drawing analogies. But I think what the court's signaling is, unless there's something that's directly on point, a very close analogical antecedent, oh boy, analogical antecedent, something in history that came before that's really close, you can't do it. So, I read one decision recently involving serial numbers. Well, there are no serial numbers on guns in the founding. And one court said that having a requirement to serialize guns is unconstitutional. I don't think the court's going to stand that one. I think the court said a lot of things in Bruin, and I don't know they're willing to actually back it up. I think they're going to run away from it, or they'll just let the lower court sort of sort it out. The big one, though, I think will be the sensitive places area. If New York can designate entirety of Lower Manhattan as a sensitive place, I think that's not going to fly. If this right means something, people who pass this gauntlet of background checks and you have to pay these fees and go through firearm training, if they can't carry in Manhattan outdoors on the street, that's not going to work. Subways might be trickier. I'm not sure. The subway is an awful place, but also it's not just the subway. It's when you get off the subway, right? In Ohio, we can all lock our guns in our trunks, right? Because we can do that. You can't do that in New York. You have no cars. You have no trunk. You have nothing. But I think that one's going to be trickier. I don't know if the court will get into the weight about the various types of weapons, so-called assault weapons. Again, to the anti-tyranny point, there's a very strong case here that they need to have big guns. I'm not sure the court's willing to go there. All right. Did I answer your questions, Lee? I think I got them in reverse order, as it were. All right, let's do some questions, okay? Yes, right over there. Can you hear me okay? Yeah, loud and clear. Thank you. Would the court ever look at the history of like other countries that have had tyranny, what they did that got them to that point? For instance, Germany, 1920s, etc. Yeah, it's actually a really good question. That's something I've done research on. Virtually every society in world history, one of the first thing they did before they came to power was to disarm people. The Germans did it, the Soviets did it. I don't care. Give me any civilization that came to power. Disarming is what they do. Even in this country, right? During Hurricane Katrina, one of the first things that the National Guard did was disarm people, go door to door, and ask if they have any guns. The pattern repeats itself that when there's some chaos, when there's some disorder, the government wants to have complete control of our arms. They don't want the people to arm themselves. And you sort of riot, people have to surrender their arms. Happens all the time. You mentioned Germany. The Nuremberg laws, one of the first Nuremberg laws was to disarm the Jews. This is one of the first laws that was passed by the Nazi regime to disarm the Jews. When you're disarmed, you can't fight back. There are instances, for example, the Warsaw Ghetto Uprising was one of the few instances where Jews actually fought back against the Nazis successfully. When I went to Yad Vashem, which is the Holocaust Museum in Israel, it's a very powerful museum. One of the most poignant exhibits I saw was actually a handgun. It was a pistol with a Jewish star carved on the handle. That was very meaningful to me. It signals when the government doesn't want you to defend yourself, they disarm you. In New York, you're a sitting duck, right? Call 911, good luck, right? Maybe get a busy signal. And the government still thinks, even after Bruin, that they can sort of resist the decision, which they will try. I would have liked, to Lee's point, if the court had at least addressed the history of disarming people in other countries. They did address the fact that the Sullivan Law, the New York law, was designed to disarm immigrants, Irish, Italian immigrants. That was who the law was designed to disarm, right? New York didn't want all these people coming off the boats with guns. They tried to disarm them. There was a racist history. Now, of course, they've reenacted it. Now it's all lovey-dovey. Everything's wonderful, no guns. But there's definitely that history there. But the court doesn't want to give lip service. Now, there's a judge. I'll say his name in a minute. I won't say it right away because it'll taint the statement. But there was a Ninth Circuit judge who said the Second Amendment was a doomsday provision, right? When all the other provisions fail, the Second Amendment kicks in. And he wrote that the Second Amendment is a right you give up only once because you can't get it back. I agree. Now, this judge's name was Alex Kaczynski. He got in trouble. He's sort of been canceled. But I think you'll at least right in that front. Any other questions? Ian?
So first, I just want to to everybody here that both Professor Blackman and Professor Sprang were, I believe, originally property professors.
That's true. Oh, that's the point.
And unfortunately, we don't get invited to this kind of thing. Just a quick thought then, a question. As far as this categorical rule strategy, reminds me of Justice Scalia's strategy in Lucas, right?
Yeah.
And the conceptual squishy test, in that the private property owner are always loses. And that seems like a pretty intentional, interesting strategy. But I worry about this case methodologically, right? I worry about the really loose use of history, the complete dismissiveness of history that's contrary to the desired outcome. And it's also really kind of odd, and we're just referring to this, to use this historical tradition argument to strike down 100-plus-year-old statue. And so I worry about it being unmoored methodologically. And it really exposes the decision to, okay, there is no methodology, this is just means-times decision making. And you can criticize that about the Warren Court, but you shouldn't then go commit the same. And then I guess one other question or thing I'd love you to comment on is this issue that Justice Breyer's dissent raises this issue of judicial restraint, right? 25 years ago, the conservative legal movement, as I understood it, was often advocating for judicial restraint. So is judicial restraint any kind of thing like fiscal conservatism that you argue for when you're out of power? And so I just was wondering.
Sure. Thanks so much, Dean. I'm grateful to be here in your law school. Um, yeah, Lee and I taught property. I still teach property. I like property. If you notice, the line "saucy intruder" is a reference to Pearson v. Post about the fox. Anyway, so if you remember from what, it just burned my retina, that phrase. Let me answer your question in reverse. Maybe I'll get to the beginning eventually. Um, Dobbs was decided basically at the same time as Bruin, right? Dobbs was a big abortion case. Bruin's decided the big gun case, and there's an asymmetry. In Dobbs, the court said the court is getting out of the business of deciding abortion cases. If the people want to enact an abortion ban, that's on you. Now we have Bruin. Bruin decided the same week. And Bruin says we're getting into the gun debate. If the people want to enact a gun ban, no, we know better, right? We're going to do it differently. You can rationalize it. You can sort of reconcile the decisions by the court saying that the right to abortion is simply made up by the penumbras, the emanations, while the right to bear arms is in its constitution. It's textual. It's there. But to the layman, to the person who's perhaps not as into the weeds as we are, they say, well, who cares? Guns are conservative and abortion's for liberals. So I think the court did open itself up to that sort of criticism that on the one hand, they're taking away the power to regulate guns. On the other hand, they're giving the power to regulate abortions. I think that's a fair criticism. At one point, maybe in the early 80s or so, the conservative movement was about restraint, sort of reactionary to the Warren Court. But I think that faded, at least when I was a toddler. I was maybe still in diapers. Justice Scalia advocated a different type of originalism that was based not on restraint, but on popular sovereignty. The idea is that the people ratified a provision of the Constitution. It was up to the courts to enact it. So indeed, enforcing the Constitution was a majoritarian process. So you move from this idea of judicial restraint to popular sovereignty, and the courts are enforcing the Constitution. Now, of course, what does the Constitution mean? I think Bruin was right. Maybe not everyone agrees. Now, Justice Breyer doesn't, or didn't much, past tense, didn't much care about constitutional law. He cared about policy and letting democracy work. He said, look, you have all these people dying. Why can't people, why can't New Yorkers regulate guns as they wish? The majority said in 40 odd states with big cities like Chicago, like Houston, like Dallas, like Phoenix, you're allowed to have public carry, won't lead to the end of the world. So it's an experiment, right? We'll see what happens in New York. As people get up, we have time? We have time? One more question, maybe?
I actually have a question.
Yeah, I want to make sure. I want to make sure you have a student question before we have to go. Anyone else? All right, hit it, Sean.
So a lot of your talk was spent dealing with state because we were primary focus on states. But this history of position test, what would that look like on some federal regimes like the NFAs and gun control act, possibly background checks in the federal system?
I think Heller and McDonald and Bruin all sanctioned background checks because they're objective, right? If you're a felon, you're a felon. If you're not, you're not. So the idea of having to wait some, negligible period before your gun releases, I think that still passes muster. What Bruin said you cannot do was have a subjective test. This is why I think this good character test for the gun laws ain't gonna fly, right? It's just like it's no different than proper cause. Anyone else? Yes, sir.
Might there be some privacy concerns mixed that might be brought up as constitutional issues? And particularly as the history of things, I recently went to national parks. I usually carry. I couldn't there.
That issue comes up all the time. Yeah.
There was on this spot, such and such, bit the hand of such and such, bit the dust of such and such's hand. Like, there's a long history in this.
Yeah, this came up during the end of the George W. Bush administration to allow carry in public parks, and just never went anywhere. I don't know if there was any movement in the Trump years. So you'd have to basically have a rulemaking to allow it. But is an entire national park a sensitive place with wild animals running around? I don't know. All right, any other questions? All right, thank you all so much. Have a wonderful day.